7 tips from a personal injury attorney that could save your case. That could be the difference between a lowball offer and full compensation. Before you call the insurance company or sign anything, watch this. Hi, I'm Brent Stewart, personal injury attorney, and today I'm going to walk you through 7 steps that could make or break your personal injury case. Every week, somebody walks into my office and tells me a story that breaks my heart. Not because of the accident itself, but because of the mistakes they made afterwards. It's not that they were careless, it's just that nobody told them what to do. The insurance company sure wasn't going to. And by the time they got to me, the damage was already done. So today, I want to give you the roadmap that I wish every accident victim had. And whether you've been in a car accident, tractor-trailer wreck, or any other type of personal injury accident, these 7 tips apply. And if you stick around until the end, I will tell you the one tip that surprises people the most. Tip number 1, know your deadlines before they pass. The first thing any accident victim needs to understand is that your case has an expiration date. In South Carolina, the statute of limitations that applies to your case is 3 years in most accident cases. If you don't file within that window, your case is gone. And for most cases, no exceptions. While 3 years might sound like plenty of time, and that time does not pause while you are treating, while you are negotiating your case, or while you're figuring out whether or not you even have a case. And here is what catches people off guard. There are shorter deadlines hiding within that 3-year window. And if your case involves a governmental entity or government vehicle, you may have only 2 years to bring your case. And in many jurisdictions, if it's a death case, a different time limit may apply. With government entities, it is important to file something called a tort claim form within the first year. Filing a tort claim within the first year can toll your statute of limitations to 3 years with a government agency. However, if not filed within the first year, your deadline is 2 years. Surveillance footage may get lost. Witnesses can move away or forget details. And medical records may make it harder for us to connect the accident to the injury the longer you wait. The best thing that you can do right now is understand time is not on your side. The sooner you take action, the more options you will have, and the stronger your case can be. Tip number 2. Document everything from the scene. Your phone is one of the most powerful tools you have after an accident, so use it. Take photos of every vehicle involved, every angle. Get the damage photos, license plates, insurance information, and road conditions. If there are skid marks, photograph them. If there's debris, photograph it. If the weather was a factor, take a wide shot that shows the conditions, or even video. Get names and phone numbers of all witnesses, because people move, forget, and become unreachable. If you have their information right from the scene, your attorney can follow up later. And write down what happened while it's fresh, not a week later when the adjuster calls, but that same day. Open the notes part of your phone and write down the time, the date, and what happened. Memory fades fast, but a written account of what happened holds up. This type of documentation may seem small in the moment, but months later, when the insurance company is disputing your allegations of the accident, it is priceless. Tip number 3. Do not give a recorded statement without an attorney. This one trips up so many people. The insurance company calls you often within hours of the accident. They sound friendly and concerned. They say they just need your side of the story. Then they ask if they can record the conversation. Here is what you need to understand. That recorded statement is not for your benefit. It's for theirs. I believe they are trained to ask questions in a way that makes you say things that will either prevent or reduce your claim. Questions like, how are you feeling today? If you say you're doing okay, that goes into the file as evidence that you're not seriously injured. Or, can you describe exactly what happened? In the stress of the moment, you may say something wrong or miss a detail that later they use against you. You are not required to give a statement to the other driver's insurance company. You have the right to say, I would like to speak to an attorney first. And that one sentence may protect your entire case. Tip number 4. Do not post on social media about your accident. I know it sounds strange, but social media is one of the biggest threats to personal injury actions today. And most people do not even think about it. So here's what happens. You're in a car wreck and you post about it on Facebook. Maybe you say something like, I had a scary wreck today, but I'm doing okay. You're just letting your friends know that you're alive. But what if the insurance company screenshots that post and uses it as evidence that you're not that hurt? Or maybe a few weeks later, you post a photo at your kid's birthday party. You're smiling, maybe you're standing up. The insurance company may say, look at this person. They say they can't work, but they're at a party doing just fine. They will search your profiles. They will look for anything that contradicts your claim. Photos, check-ins, comments, even things your friends tag you in. In Discovery, they ask for every social media handle that you have. They don't ask for these social media handles to help you. They're going to scan through all your social media to find things that help them. My advice is set your profiles to private and quit posting about your life until your case is settled. Don't post about your accident, don't post about your injuries, and don't post about your day. Anything you put online can and will be used against you. Also, it is a bad idea to post things online that you think will help you. People often post things thinking this will help show their injury, but in reality, it does not help you. Tip number 5, keep every record related to your case. Organization wins cases. I've seen this over and over. The clients that keep better records often get better results. Here is what I mean. You want to keep a journal of what's going on, but you don't want it to be too detailed that you look litigious. For example, if you have to hire somebody to mow your lawn because you can't do it yourself, write that down. If your spouse has to take time off work to take you to appointments, document that. These are real losses and they can be a part of your claim. Create a folder, physical, digital, and put everything in it. When your attorney needs something 6 months from now, you'll have it ready. And if the insurance company says this injury did not really affect your life, you'll have a stack of evidence to contradict this theory. Tip number 6, do not accept the first settlement offer. This is a major trap in personal injury cases. The insurance company can make an offer early, sometimes within the first few weeks. And in the heat of dealing with lost wages and medical bills, that offer can be tempting. But here's what they're counting on. They're counting on you taking the offer before you know the full extent of your injuries, before you've finished treatment and seen a specialist, before you know if you need a surgery or long-term therapy. Because once you accept a settlement, that is it. You sign a release and you give up your right to come back for more money. Even if your injuries get worse, even if you need a procedure that you did not know about, even if you can't return to the same job, the first offer is almost never the best offer. It is a starting point for the insurance company to close the file quickly and cheaply. A good attorney can tell you their opinion as to when the offer is fair or not. And in many cases, negotiating or progressing further in the case can get a significantly larger offer. Patience is one of the most valuable things you can have. Tip number 7. Talk to an attorney before you talk to anyone else. I save this for last because this is the one that surprises people the most. It's one of the things I hear most often when somebody comes to me after making mistakes earlier on. People seem to think that they need to handle things with the insurance company first and then come to a lawyer if things go wrong. But by the time things go wrong, the damage is already usually done. You've given a recorded statement, you've signed something that you shouldn't have, or a deadline has already passed. Remember, in South Carolina, in most cases, the statute of limitations is 3 years for personal injury actions. In workers' compensation cases, the statute of limitations is 2 years. So the sooner you talk to an attorney, the stronger you can make your case. Here is another thing most people don't realize. Most personal injury firms, including ours, offers free consultations. You don't have to pay to sit down and find out where you stand. If we end up taking your case, we get paid on a contingency fee, which means you don't pay anything unless we win. So there is zero financial risk in making the call. These are the 7 tips I would give anybody dealing with a personal injury action in South Carolina. I will run through them one more time. 1, know your deadlines before they pass. 2, document everything from the scene. 3, do not give a recorded statement without an attorney. 4, stay off social media. 5, keep every record related to your case. 6, do not accept the first settlement offer. 7, talk to an attorney before you talk to anyone else. If you're watching this and you've been in an accident, it is not too late. Even if you have made a few of these mistakes, there may be some options available. The sooner you act, the better. Click the link in the description for a free consultation. And if this video helped you, subscribe and send it to somebody that might need it.